History's strange, it's alien, and it won't give us what we would like to have.
So here's the thing these days. I don't anymore just stop my day and start reading and listening to Supreme Court oral arguments. Used to do that quite a bit in the days of Constitution Thursday. Now, not so much. It's lawyer country. It's necessary. It's important. But it's not normally where I live as a historian. It's just not, folks. But this week, of course, something in one of those arguments just stopped me cold. Not because of the outcome, which we do not as yet know. Not because of the policy questions involved. It was because of how history was being used in the argument, or I guess more accurately, misused. During arguments over a Hawaiian firearms law, lawyers were defending the statute cited in the case, and they used post-Civil War black codes as a historical precedent. Now, just let that percolate for a moment. Just let it settle. The black codes, for those of you who do not know or don't remember or never knew, were laws passed in the immediate aftermath of the United States Civil War in southern, read that as former Confederate states. They were used to control, restrict, terrorize newly freed black Americans. These were laws that were so abusive, so restrictive, so evil, that they triggered Congress to pass the Civil Rights Act of 1866, and eventually they led to the 14th Amendment in 1868. You follow me here? These black codes, these laws, were so abusive that they caused the 14th Amendment. It was a direct reaction to those. Those laws were offered up in the chambers of the Supreme Court this week of the United States as examples of acceptable historical regulation. Now, if you're not a historian of the Reconstruction, that may sound a bit odd. If you are a historian of the Reconstruction, it feels like you're watching someone point to a house fire and say, that's a pretty good heating system. Now, before we go any further, this is not about whether or not Hawaii's law is good or bad. That's a discussion for another place. Reasonable people can disagree about that. It's not about partisan politics. This is about historical reasoning and whether the past is being treated as a story with meaning or as a pile of legal scrap metal being repurposed. The black codes were not just another set of old laws. They were an emergency response by defeated elites trying to nullify emancipation without restoring slavery by name. It was in function, but by name, since they couldn't call it slavery anymore, they tried to restore it, and that matters. To understand why this argument this week in the Supreme Court was so jarring, you have to go back to 1865. The war had ended. Slavery was legally dead, more or less. The Emancipation Proclamation had taken effect. 4 million people were stepping into freedom with almost nothing but the clothes they were wearing, and the expectation, however fragile, that freedom meant autonomy. It meant liberty. At the same time, southern state governments were reconstituted, and in many cases they were run by the same men who ran them before and sometimes even during the war. These men understood something very clearly. If freedom operates normal, if labor is negotiable, if black citizens can then move, bargain, vote, testify, and defend themselves, the entire power structure of the Southern tradition collapses. And so they decided to act quickly. The black codes are passed in these southern states in 1865 and 1866. They don't announce themselves as racist laws. They almost never say the word black. They talk about things like vagrancy, about contracts for labor, about public order, and, notably because of what was discussed in the Hawaii law in the Supreme Court, about weapons permits. On paper, these laws look very tidy, very neutral, very administrative. But in reality and in practice, they are precision instruments. Vagrancy laws criminalized unemployment for freedmen, but not for white laborers drifting between jobs. Fines are imposed that cannot be paid. Failure to pay them meant forced labor. Wait, forced labor. What is forced labor? Apprenticeship laws allowed for black children to be bound to white employers without the parental consent. Courts continued to bar blacks from testifying against white defendants. Justices were, of course, all white. Sheriffs enforced the laws selectively, and judges exercised discretion only in one direction. And then there was disarmament. Several states explicitly prohibited black citizens from possessing firearms or ammunition without permission. Licenses were theoretically available, but practically unreachable. Enforcement was ruthless. The result was not public safety. It was enforced vulnerability. This is not speculation. This is documented reality. Disarmament made it easier for paramilitary groups like the Ku Klux Klan, the White League, to operate with impunity. Night riders did not fear any resistance. Law enforcement often was the resistance, or worse. This was not regulation, it was control. And in Congress, they understood this immediately. Well, maybe not immediately. It took a little bit of time, but Congress began to realize that this is not good. The Freedmen Bureau reports they were getting were horrifying. Northern outrage followed very quickly. Reports from that Freedmen's Bureau made it clear what was happening. The black codes were not viewed as imperfect laws that needed tweaking. They were viewed as proof that Southern states cannot be trusted to protect basic civil rights. The states were not doing what they were supposed to do. So in 1866, Congress passed and enacted the Civil Rights Act of 1866. It was supposed to protect those rights. The problem was it was marginally effective, and there were some constitutional questions about whether or not the Supreme Court would uphold it or not. This is why the 14th Amendment exists, not as an abstract philosophical refinement, but as a direct response to these black code laws. That's the key historical point in all of this, and it's the one that watching the Supreme Court this week seems to have forgotten. The black codes are not part of the constitutional tradition that the 14th Amendment preserves. They are the abuses that required it in the first place. That means those black code laws are not precedent. They are evidence of failure. So when those laws are cited in a modern courtroom, not just a modern courtroom, the Supreme Court, as examples of acceptable regulation, something has gone badly wrong. Cause and effect have been reversed. The disease is being treated as proof that the cure was unnecessary. The argument you heard in the court, if you listened to it, was not an endorsement of the black codes as good law. It was an attempt to use them instrumentally as evidence that restrictions once existed and therefore may exist again. That distinction matters because it reveals the core problem. The argument treats history as a quarry to be mined, not as a narrative. It assumes that existence alone of something confers legitimacy. That's not how history works, and it's not how constitutional development actually functions. Now, To be fair, the lawyers who made this argument are kind of boxed in by the court's own doctrine. There's a test called the Brunn test that requires modern laws to be justified by historical analogs. When you do that, lawyers start digging. And when the ground is very thin, they dig deeper. And occasionally, as in this case, they dig into what can only be called contaminated soil. It explains the argument. It doesn't make the argument sound legally, morally, or historically. Several of the justices reacted visibly. Justice Gorsuch called the citation, quote, astonishing, unquote. Justice Alito pointed out the bitter irony of using laws designed to leave black citizens utterly defenseless as justification for modern restrictions on firearms. Justice Thomas emphasized that the 14th Amendment was enacted especially and purposely to defeat this kind of law. That reaction was not ideological, it was structural. It was the instinctive recoil of anyone who understands what those laws are for. Now, let's address the part that troubled many listeners the most. Justice Brown, Ketanji Brown Jackson's response. It is tempting to read it as historical ignorance. It's very easy to do that on the conservative side. That may be an oversimplification. What she's actually doing is criticizing the method. She's pointing out the fact that the Brunn framework forces the lawyer to cite historical restrictions, even shameful ones, to prove that regulation has a tradition. That critique is not wrong, but it causes a situation where, as historians, we have to speak up. Method and meaning cannot be separated so neatly. A framework that treats all past laws as interchangeable, regardless of their intent or effect, is not historically neutral. It's historically illiterate. The Black Codes were not part of a normal regulatory continuum. They were an emergency countermeasure enacted by Southern Confederate former states against emancipation. Any method that flattens that distinction, any argument that tries to rationalize that, is a broken one. And this is where my concern lies with the whole thing, not just with one justice, but with how history is being handled by institutions which wield actual power. History is not a grab bag. It's not a narrative of cause and consequences. Some laws exist to teach us what to avoid. Others show us what was actually endured. Mixing them together without context does not honor history. It abuses it. For veterans, this should sound familiar. Rules matter. Intent matters. Chain of command matters. When someone points to a past failure and says, well, that's the doctrine, alarm bells should go off. The Black Codes should set off alarm. They remind us that law can be used as a weapon without ever firing a shot, that rights declared without enforcement are temporary, that neutrality on paper can mask cruelty in practice. They also remind us that progress is fragile. Reconstruction showed what multiracial democracy could look like under federal protection. The Black Code showed us how quickly it could be strangled when that protection was withdrawn. So how should we respond to this moment? Well, calmly, obviously, precisely, perhaps without as much heat as we've been tempted to pour on this. We can say this. The Black Codes are categorically disqualified as precedent because they represent constitutional collapse, not tradition. They are the reason the 14th Amendment exists. Using them to rationalize modern law reverses the logic of Reconstruction and completely empties it entirely of its meaning. History does not ask the court to reach any particular outcome in this case. It only understands that history be understood accurately and used properly. Some beams in the structure of American law are load-bearing. Others cracked and they failed under pressure. The Black Codes are in that second category. They are warnings carved into the wood, not blueprints to be reused. If history is treated as ammunition, it will always be misfired. If it is treated as instruction, it still has something to teach. This is why that moment matters. Not because of Hawaii's law, whatever you may think of it, not because of firearms, but because it revealed how easily the past can be misunderstood when it's treated as a citation instead of a story to inculcate values. And that, my friends, is why historians exist. Because some cracks in the plaster of the wall are not decorative. They are reminders of what happens when the structure fails, and of what it took to build it.
Check out more stories from history at davedoeshistory.org.